Wasserman and I work with CCPR Center. I have the pleasure to be here with Mrs. Rachel Brett, who will tell us about the impact of the recent case Atasoy and Sarkis versus Turkey on the right to conscious belief, to conscious of objection, and we'll make a comparison with the jurisprudence of the European Court for Human Rights. So Rachel, would you expand on the development of the jurisprudence in respect of the right to conscientious objection and in comparison to the Human Rights Committee's jurisprudence?
The question of conscientious objection to military service originally was not considered as a right by either the European human rights institutions. At that stage, this is now many years ago, it was the European Commission on Human Rights. It didn't get as far as the court, or the Human Rights Committee. The Human Rights Committee then moved slowly over a period of years to change its position, really starting in 1993, or the first major evidence of that was 1993, when it did its general comment on Article 18, the right to freedom of thought, conscience and religion. Then, at a later stage, it actually did its first case in which it came back to the fundamental question of whether conscientious objection to military service was protected under the Covenant. And that was the Korean case of Yoon and Choi. And it actually said, yes, it is protected under the right to freedom of thought, conscience and religion. At that stage, the European institutions, the European Court of Human Rights, had not reached that position. The first case after that went to the European Court, which was an there was first a Turkish case of Ulka versus Turkey, and he was a conscientious objector. The European Court of Human Rights found in his favour, but they found in his favour on the basis of inhuman and degrading treatment because of his repeated prosecution. And because they'd found on that, they said, we don't need to decide on Article 9 for them, the right to freedom of thought, conscience and religion. The next case was an Armenian case called Bayatian, a Jehovah's Witness. And in the chamber, they said, in fact, that conscientious objection to military service is not protected under the European Convention on Human Rights. So you actually had a complete contradiction between the Human Rights Committee and the European Court. That case was then appealed to the Grand Chamber, and my organisation, the Quaker UN Office, was concerned because in the Chamber they had not considered the UN jurisprudence, particularly the Human Rights Committees, at all. And so we asked for and got permission to do a third-party intervention, an amicus brief, together with Amnesty International, the International Commission of Jurists, War Resisters International, and Conscience and Peace Tax International, in which we actually set out for the court not only where the Human Rights Committee had got to, but how it had reached that point.